Donald Trump moves to recuse Judge Chutkan. Judge Chutkan, of course, presiding over the January 6th prosecution brought by special counsel Jack Smith. And this was a big one. We've all been waiting for this. We know that Judge Chutkan has been involved in sentencing other January 6ers. Two people named Christine Priola and Robert Scott Palmer, in fact, were sentenced in her courtroom. And during those sentencing proceedings, she had some commentary about Donald Trump. But the point here is that Donald Trump's team is saying this means this judge is biased. She is no longer capable of being fair and impartial to a new set of facts that are in front of her because she's already made her opinion known in prior cases. And so these are two exhibits that Trump's team has actually submitted as attachments to the motion for recusal. Let's take a look at what Trump and his defense team submitted here. 9 pages submitted on 9/11/2023 in the United States District Court for D.C. This is Judge Chutkan's courtroom, so she's going to be getting this filing. And we know, as we've talked about here on this channel, when we've talked about this question, as it's come up many times, what can we do about this judge? Can we recuse this judge? Well, we've looked at the law, and it is a very high standard. It's not just something easy. In some other states and some other jurisdictions, like here in Arizona, for example, there's a much easier mechanism to get a different judge. You just file a notice for a change of judge. This is a much more robust standard because we're at the federal level. And let's see what their argument is. Donald Trump's lawyers writing, Your Honor, this is Donald Trump's motion for recusal of the district judge pursuant to U.S. law. They say President Trump hereby, through his lawyers, respectfully moves to recuse and disqualify the Honorable Tanya Chutkan pursuant to the law. Trump's defense says, and they're writing this to the court, so it's going to be to Judge Chutkan, really, and she's going to rule on it, says, fairness and impartiality, Judge, are the central tenets of our criminal justice system. Both the defendant and the public are entitled to a full hearing on all relevant issues by a court that has not prejudged the guilt of the defendant and whose neutrality cannot reasonably be questioned. And so this is going into the court and telling the court, Judge Chutkan has, in connection with other cases, suggested that President Trump should be prosecuted and imprisoned. Such statements made before this case began and without due process are inherently disqualifying. Although Judge Chutkan may genuinely intend to give President Trump a fair trial and may believe that she can do so, her public statements unavoidably taint these proceedings regardless of the outcome. Even if she is fair, the statement she's already made, it's already ruined because of her. The public will reasonably and understandably question whether Judge Chutkan arrived at all of her decisions in this matter impartially, we're already asking that, or in fulfillment of her prior negative statements about Trump. Under these circumstances, the law and the overwhelming public interest in the integrity of this historic proceeding require recusal. And we've seen this, okay? Judge Chutkan has already issued what I would say are insane rulings as we've read through them. One example of this is the discovery and trial date rulings that she has made. Trial is scheduled for next year, 2024, in March, and Trump's defense, according to the government's own numbers, have 12.5 million pages, give or take, of documents that they need to comb through. If you calculate that, that's 10 Washington monuments. It's a ton of material. The judge said you can read it quickly because the government prosecutor named Molly organized it nicely with sticky notes and highlighters. All right, it's insane. Basically saying to the defense, you don't get to read the evidence. And so we're already asking questions about this. This case has barely even started. And it's almost like she wants it to be rigged against Trump because they can't even read the evidence. But they have some other disqualifying statements here. They say, hey, D.C. court, in October 2022, before the special counsel's appointment or the filing of this case, here's something that Judge Chutkan said. Before we even had an attorney appointed in October, Chutkan says, this was nothing less than an attempt to violently overthrow the government, the legally, lawfully, peacefully elected government by individuals who were mad that their guy lost. That's Trump. Chutkan says, I see the videotapes. I see the footage of the flags and the signs that people were carrying and the hats that they were wearing and the garb. And the people who mobbed the Capitol were there in fealty, in loyalty to one man, not to the Constitution, of which most of the people who come before me seem woefully ignorant, not to the ideals of this country, and not to the principles of democracy, she says. It's blind loyalty to one person who, by the way, remains free to this day. And I was thinking about this. You know who set him free today? This was back in 2022. you, right? So she's here complaining and moaning, oh, Trump, 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 he's still free. Nobody's done anything about this, blah, right? Who remains free to this day. Well, Trump showed up in her case on arraignment for this court, and she let him out on his own recognizance. He's still out of custody. He's still free to this day, Judge. He's already come through your courtroom. He's still free. You could have locked him up. If you really thought that this was nothing less than an attempt to violently overthrow the government, led literally, done in fealty to one man, it's blind loyalty to one person. They were there in fealty, in loyalty to one man, all right? In other words, they were there, he caused it, and she let him walk out of the courtroom. Amazing. That's weird. Why did she let an insurrection, violent overthrower of the government out? It's because this is all just nonsense. Now, we'll come back to that. This is the excerpt. They say, court, the public meaning of this statement is inescapable. President Trump is free, but should not be. It's an apparent prejudgment of guilt, obviously. These comments are disqualifying standing alone. However, this was not the first time that Judge Chutkan expressed such an opinion. Before that, in December 2021, she similarly stated the following thing. She suggested, in her view, this is Trump's lawyer saying, that Trump was responsible for January 6 and should be prosecuted. Here's what the judge said. He went to the Capitol because despite election results, which were clear-cut, despite the fact that multiple court challenges all over the country had rejected every single one of the challenges, Mr. Palmer didn't like the result, the man who's been charged and sentenced here. He didn't like the result, and he didn't want the transition of power to take place because his guy lost. And it's true, Mr. Palmer, this is the judge scolding him, you have made a very good point, one that's been made before. Take the people who exhorted you and encouraged you and rallied you to go and take action and to fight, that they have not been charged. Oh, like who? Like Trump? That is not this court's position. I don't charge anybody. I don't negotiate plea offers. I don't make charging decisions. I sentence people who have pleaded guilty or have been convicted. And the reason why the judges are not supposed to make charges, because if you're judge, jury, and executioner, that's kind of like an insane system, unless you're Hollywood. The issue of who has or who has not been charged is not before me. I don't have any influence on that. I have my opinions, which she's communicated, but they are not relevant. So she's saying to this gentleman, so you have a point that the people who may be the people who planned this and funded it and encouraged it haven't been charged, but that's not a reason for you to get a lower sentence. So in making these statements, Trump's lawyers say the following. Chutkan agreed with portions of his sentencing memo, the defendants, which similarly and wrongly placed the blame on President Trump, and both complained that he had not been charged. The defense lawyer for Palmer said, quote, those voices, including the voice of the then president himself, had convinced persons like Mr. Palmer that the election was fraudulent and that they must take action to stop the transition. So they're all pointing their fingers to Trump, which I think is a perfectly fine defense strategy. While many of the people who participated in the Capitol riot will be going to prison, the architects of that event will likely never be charged. They say, although Judge Chutkan correctly noted that she doesn't have any influence on the charging decisions, she did say you made a very good point that the people encouraged you have not been charged. And this is a reflection on her apparent opinion, right? So they're really parsing her words, saying if you break that little sentence down, what she means is Trump's conduct, one, occurred, and two, that she supports the charges. Otherwise, she wouldn't have characterized his point as being very good. She said, very good point there. Why hasn't he been charged? Similarly, she said, I have my opinions, suggests in her view that almost 2 years before the initiation of this matter, President Trump should be charged. So they continue, Your Honor, with all of your prior statements here before you in your D.C. court, public statements of this sort create a perception of prejudgment incompatible with our justice system. In a case this widely watched of such monumental significance, the public must have the utmost confidence that the court will administer justice neutrally and dispassionately. Judge Chutkan's pre-case statements undermine that confidence and require disqualification. Now here's the law, and let's spend a minute on this. They say unbiased, impartial adjudicators are the cornerstone of our system. Any judge shall disqualify himself when their impartiality might reasonably be questioned, right? A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence. Now, we're asking ourselves, right, who decides whether a judge is impartial or whether it is reasonable or whether her impartiality can reasonably be questioned? What they're giving us here is an objective standard. Rather than asking her, hey, judge, are you biased? And she says, no, I'm not. We're not really concerned about her personal opinion or Trump's personal opinion or anybody's subjective opinion. We're zooming out on this and saying, what would a reasonable observer, any third party, say about this? Like, swap the defendants out. Like, if that was your kid in there instead of Trump, would you still be okay with that? If that was Barack Obama in there instead of Donald Trump, are you still cool with Trump's DOJ prosecuting everybody? Under settled law, what matters is not the reality of bias or the prejudice, but its appearance. That's a Supreme Court case. Therefore, all that must be demonstrated to compel recusal recusal is just the showing of an appearance of bias. That's it. Sufficient enough to permit an average citizen reasonably to question a judge's impartiality. So it sounds like a pretty low standard. This inquiry is an objective one, made from the perspective of a reasonable observer who's outside the case. In other words, it's of no consequence that the judge is not actually biased, right? It doesn't matter that she's not actually biased. It just is whether it appears. Fifth Circuit stated, the overriding concern with appearances stems from the need to have an unimpeachable judicial system with unwavering confidence. They've wrecked that. Therefore, to preserve the reality and the appearance of impartiality, a judge should recuse herself when her impartiality might be reasonably questioned. Obviously, she's not done that. They go into argument. They say the following. Here, to the D.C. court, there is little doubt that reasonable members of the public might, in viewing Judge Chutkan's statements, believe that she has prejudged both the facts pertinent to this case and Trump's culpability. Her statement, when she said it's blind loyalty to one person who remains free, they say straightforwardly, and of course incorrectly in the defense's view, suggests that Trump is culpable for January 6th and that he should not be free. That's how I read it. This would be a natural interpretation of her comments in any context, but it's particularly poignant here, where Chutkan directed her statements to a defendant she was about to sentence to an extended term of incarceration. Her comments suggest that she had reached a conclusion before this case that Trump is more deserving of a term of imprisonment than the defendant she was sentencing. She brought up Trump in Palmer's sentencing. Likewise, most reasonable observers would understand Judge Chutkan's statements that it is true, Mr. Palmer. She said, you made a very good point, one that's been made before, but I have my opinions. She did say that Trump exhorted, encouraged, rallied others, and it's a suggestion that Trump should be prosecuted. So they quote some case law, 10th Circuit. They say courts have found an impermissible level of bias when a judge's remarks or actions reveal that she has prejudged the guilt of a defendant. Sounds like she has. She's seen enough evidence here from other January 6 cases. Trump's defense says Chutkan made her comments from the bench during court proceedings, which only amplifies the concern of prejudgment. She didn't do it to media. She didn't do it outside the courtroom. It was in the courtroom on the record to a defendant. President Trump was not a party to those cases. He has got no ability to object or persuade the judge, and she just made him. They say the indictment here does not even allege Trump personally entered the Capitol or incited violence. It makes numerous allegations that he made false claims. While Trump denies these, Judge Chutkan's comments can reasonably be understood to mean she's already formed an opinion about his guilt and many of the allegations in this case, obviously. Moreover, because the statements were made on the record in support of incarceration sentences, the public must reasonably understand her statements to be the product of considerable thought, right? She's not just riffing off the cuff here, ranting at a party or something, caught off mic. No, she's sentencing somebody on the record. There's a court reporter writing it all down, saying that this is reflective of her core views. Unlikely those things are changing. And here, as President Trump's supposed culpability was not an issue for her, she wasn't talking about Trump or making decisions in those other sentencings, they can say that she got her views about Trump from extrajudicial sources, right? Trump was not on trial in front of her. He is now, but he wasn't back then, so why was she commenting about his criminality when she had not seen any evidence about it at all, unless she had already come to her own conclusion and connected Trump to these defendants? Trump's people say every judge must uphold her oath of office. That is, to faithfully and impartially discharge and perform all duties incumbent upon the Constitution and the United States. So help me God, that's the code. The foundation of that oath is a judicial branch designed by our founders to be entirely impartial and avoiding even the perception of prejudgment. I harp on this a lot about how the legitimacy of the institution is a real catastrophe for this country, and I can't even articulate how important it is. When people stop believing the system is impartial, or they have faith that it is legitimate, it feels partisan, the whole system stops working. Like, that is necessary for it to work. And we talked all about this in the founding papers of this country, which is why legitimacy is so important, and they're just throwing it right in the garbage. Our system guarantees that the government prove a defendant guilty in front of a jury of his peers as part of a trial without any suggestion of partiality on the part of the presiding judge. Only when all three prongs are present and beyond dispute does our system function as intended. It's right. If you don't have it, it's like you might as well just not have a heart or a brain. It just doesn't work. Both by its procedure and its content, this trial is a test of the very foundations upon which our government is built. There is an overwhelming public interest in ensuring the perceived fairness of these proceedings. In a highly charged political season, naturally all Americans, and in fact the entire world, are observing these proceedings closely. Only if this trial is administered by a judge who appears entirely impartial could the public ever accept the outcome as justice. The law commands a judge to recuse herself if her impartiality might reasonably be questioned. The standard is not particularly particularly high, especially in a case, as here, where the DOJ answers to a president who is prosecuting his main leading opponent in an election that will take place in just over a year. Now, they say the standard is low. Now, legally, you might say so, but as a practical matter, judges don't get recused regularly. Now is not the time for the American people to second guess a judge's impartiality, even though I agree completely that she should be recused. Rather, the court should ensure the public remains unwaveringly confident in its decisions and its commitment to the fair and impartial administration of justice. Therefore, President Trump requests Judge Chutkan recuse herself from further proceedings. For the foregoing reasons, Judge Chutkan should recuse herself and direct this clerk to randomly assign this matter to another district judge. So, judge, recuse yourself, and then clerk, give it to someone else. Additionally, given the overriding public interest in ensuring the appearance of fairness in this proceeding, President Trump requests the court consider this motion on an expedited basis and, pending resolution, withhold rulings on any other pending motions. So don't work on anything else that you're working on. All right, so we'll see what the DOJ comes back with. Now, you'll see here that there were 2 sentencings that were also brought up. We read a little bit of the highlights of them in the actual filing, but let's just take a quick look at what they included. We have here 8 pages, and this is the case, Donald Trump being prosecuted in Judge Chutkan's courtroom, District of Columbia. We see this is Exhibit A, and this is just an excerpt from the sentencing in Judge Tanya Chutkan's court. So this was some time ago. This is exactly what they were referencing in their filing. This is the final sentence from Miss Priola. She's telling the judge, Judge, Your Honor, I just want to be a good example in the world of how to help families not be divided, and coworkers and friends not be divided, and our nation not be divided. I just really want to try to do that. And whatever sentence you give me, I hope it just brings justice and peace, some peace to the people that I've hurt. Thank you, Your Honor. And she says, thank you, Miss Priola, the judge. After calculating the sentencing guidelines and the departures and hearing the statements, I now have the difficult job, as I ever do. I have to impose sentence. The government has stated these purposes, and I don't need to list them all again. We're familiar with January 6th, says Judge Chutkan. We've had close to 900 prosecutions all brought in this court. This is a small court. All judges are taking their fair share of these cases, myself included. What does this have to do with anything? And every case presents a different defendant in a different situation, and I know my other colleagues endeavor to treat each person as an individual and not part of a mob. And we have to be mindful of what happened that day. So she's talking about how busy they are, right? Every single time that I see a videotape of what happened that day, I'm struck anew with both the horror of what was going on that day and how close we came to not fulfilling one of the basic functions of our democracy, which is the peaceful transfer of power, which we lecture other governments all over the world on, now she's literally part of the prosecution that is prosecuting a political opponent of the guy in power who's her party. We should be lecturing ourselves. We are lecturing. We're lecturing you, Judge Chutkan, for being a part of the problem, for being a part of the evaporation of the democratic ideals. We're supposed to be an example of not prosecuting our political opponents in America, but you're not going to sentence yourself, are you? And so while Mr. Langmark, they say, this is Judge Chutkan, is correct that your background didn't involve any criminal activity, Priola, the events of that day and the seriousness of those events cannot be understated. This was nothing less than an attempt to violently overthrow the government and the legally, lawfully, peacefully elected government by individuals who were mad that their guy lost, right? There is no mob without members of the mob, and Trump remains free to this day. He should be incarcerated if she had her way. If she was prosecuting this, he would have been rounded up. So Mr. Langmark made a point in his sentencing recommendation. If we were to take your participation out of that group, everything would have still happened, but you were there. And the people in ways, they act in different ways when they're with a mob. And you're one of a few defendants, Miss Priola, to at least acknowledge the harm. But you and other rioters are calling themselves patriots. Oh man, that makes her, I think, skin crawl, probably. Nothing could be further from the truth. The people who stormed the Capitol that day were what? Federal agents, Ray Epps, FBI agents, pipe bombers that never got found, FBI's most wanted list, like Ray Epps, who, so very dramatic, okay, very theatrical. And the same thing is happening in the other type of sentencing where she says much the same thing in the case of Robert Scott Palmer. So this is Judge Chutkan, obviously very biased, very partisan, and that is just her prior statements. They didn't go into anything in this case that we've covered thus far, which of course includes a lot of other problems, like the fact that she said it was reasonable for the defense to read millions, literally millions of pages of documents before trial starts, which is going to be happening in March. So lunacy. Donald Trump files a motion for recusal. Government's going to respond. And if I have my guess on it, Judge Chutkan's not going to recuse herself, which means we'll be seeing more of her, and we'll continue to cover, my friends.